The first and only matter to come before us this morning is State of Ohio versus David Choate.
Choate.
Choate, thank you.
We were placing bets on that. I don't know.
The state has waived oral argument. You have 15 minutes starting this morning. We've read the briefs and we are ready to proceed when you are.
Thank you. May it please the court, James Armstrong, on behalf of David Choate Jr. Just for those of you that know me, it's an allergic reaction to medication I was taking. So if you're wondering when you saw me what happened, that's what that is. But to get to the, I beg your pardon, Your Honor?
I said I didn't even notice this now. I hope you get better.
The issue in this case is whether grand theft, well, there's many issues, but whether grand theft, and grand theft occurring at the same time against the same business at the same place are allied offenses pursuant to 2941.25. This case is somewhat unique because by the time I filed my initial brief and then the state filed a brief, the Supreme Court came out with State v. Ruff, and thus I filed my reply brief addressing that, and even under Ruff, certainly the three questions that are answered in Ruff all indicate that these would be allied offenses. One, were the offenses dissimilar, import, or significant? Well, stole items from a business. Were they committed separately? No. It was all at the same time, same place, same circumstances, same community. Were they committed with separate animus or motivation? Well, certainly not. The state's own case said he was motivated because his former employer who advanced excavating, who was the victim in the matter, was his former employer, and they used that as the motive against that. In fact, in their brief, the state essentially concedes 2 and 3, but then without any notice of the record tries to argue that the offenses are dissimilar. How that is left unclear in their brief. I submit to the court that when a theft offense occurs at the same time, at the same place, against the same person, they are allied offenses. If not, then I don't know how we even have allied offenses. It's the exact same charge, F4s, occurring at the exact same time. They should have been merged, and you should not have received the consecutive sentences on each and every one, let alone maximum sentences.
What if it was a car dealership and there were 30 cars taken? Would you still have the same position?
Well, 30 cars were taken, Your Honor. The value of those cars would be in excess of $150,000, so you would have the ability to change that. Could the prosecutor be creative and come up with other crimes to handle that situation? Yes. My experience is that the prosecutor can be very creative when they want to, when they do an indictment. In this case, they did not do that. They indicted 3 counts of grand theft. They all occurred at the same time. They didn't make any other, well, there was an indictment for breaking and entering as well, but which he was convicted of. But they didn't do anything regarding conspiracy or the RICO offenses that possibly could have been involved, since there are other people that were involved in co-defendants. So under those circumstances, if they charge 30 counts of grand theft, I'd say yes.
That's what I was getting at.
I would say yes.
So it has nothing to do with how many items were taken, or the trial court looked at it here as like different purposes, looking at animals maybe in that respect.
I understand that, Your Honor, but the trial counsel for Mr. Choate did a good job. Pretty much, we don't have any plain air arguments here. He objected all along the way to pretty much everything that I cited in my briefs to the court. That under that argument, and I thought it was a good analogy, that if every time you take a hammer, instead of combining it like they did, well, the hammer's worth $30, well, that's a misdemeanor. Well, the weed trimmer is worth $100, that's a misdemeanor. You could go through and you could end up having 30, 40 misdemeanors, all of which by statute were concurrent.
If I may, is there any significance to the fact that the state was addressing aiding and abetting? The convictions were 2 convictions for tools in the red truck, I believe, were for aiding and abetting. That was one of the reasons they brought those. It wasn't a direct thing, but it was aiding and abetting those things. It's just how you end up with the grand theft. Is there any significance to that?
I would say for purpose of allied offenses, no, because when did they occur? At the same time, same place. It wasn't like Mr. Choate went in there, took some items, and told his buddy, hey, you know, you could go in there, there's no security, or the gate's broken, or whatnot, and take what you want. They were all there together at the same time. They came at the same time, they left at the same time. That's pretty clear from the record, Your Honor. And as I state, that's the exact same charge he was indicted for and convicted of. And as such, how we don't get allied offenses and how they get merged, I honestly can't understand that because they seem pretty clear that they should have, Your Honor. We also had the issue that we had maximum sentences involving, this court's still following the state versus Kalish position with regard to abuse of discretion. First, obviously, you check on, I know I'm speaking to the court knows what it does, but for purposes of the record, you look to make sure the felony sentencing guidelines of 29-29-11 are applied, and then whether or not, if so, whether the sentence was an abuse of discretion. For purposes of reference, in State versus McCowan, which came out last month, which was actually my case, I did file a motion to certify a conflict based on the fact that other jurisdictions will address the issue based on a clear and convincing standard using the statute, and the court noted a conflict in the footnote in that case, so that is one that I filed a certified conflict. But using the existing law here, I submit that the felony sentencing guidelines were not followed. The purpose were to punish the offender using the minimum sanction to accomplish these purposes. The need to incapacitate the offender, deter the offender from future crime, rehabilitate the offender. It was clear that Mr. Choate had a terrible heroin addiction. It stated in the record that was the reason for his desire to try to get money to feed that heroin addiction. The heroin addict who targets a former employee certainly could get drug treatment in less than maximum sentences on everything that was possible to sentence him on.
But it seems like he's had a lot of help in the past. He's had a lot of community control sanctions. He's been in prison. He's had a lot of, what more is a court supposed to do? As sympathetic as it may be to that addiction, what are you supposed to do?
Your Honor, if we're looking at what is the minimum sanction to apply, I even mentioned in my report, because of that past record, I could see the court ordering a prison sentence. What I didn't understand was 3 consecutive prison sentences totaling 54 months to address the heroin addiction and even to deter the crime. This was not a violent crime. It didn't happen during the daylight. Nobody was physically harmed. I'm not trying to excuse theft offenses, but in the big picture, maximum sentences for conduct of somebody targeting a former employee, a former employer who refused to hire her back, while not okay, didn't justify the maximum sentences. And I submit that on the first phase of felony sentencing, the minimum sanction was not really even considered. It's the reason why I addressed whether or not he was actually punished for going to trial. This court had talked about the overt statements in, I think it was State versus Palmer last year, if I remember correctly, in which the court simply said, well, if you plead here, you could get this, but if you take it to trial, I might have to consider something else. Here he took it to trial, and there was no overt statement, but when you look at maximum sentences run consecutively, when you look at no jail time credit, when you look at no hearing on the restitution, I think it does wonder whether or not the trial court did take into account that, well, you took this to trial and you really should have taken this to trial.
The state recommended, what, a three-year sentence?
The state recommended a 3-year sentence if he pled, but they were not willing to address the issue of whether they were allied offenses, and the court was not willing to tell ahead of time whether they thought grand theft or grand theft were going to be allied offenses. So in order to preserve that right for obviously appeal and for review, if the court did ultimately what it did, obviously the trial had to go forward, Your Honor, and it's a constitutional right of my client to go to trial, and he took advantage of it.
So the court, and of course the court's not bound by the prosecutor's recommendation, but so the court basically gave him 18 months more than the prosecutor recommended.
Correct.
And he had several co-defendants, or at least there were several other individuals charged in this enterprise, which he engineered, correct?
According to what the jury found, yes. Yeah, sure. Interesting thing about that fact is when you look at what the prosecutor did with every one of those people received some kind of very, very wonderful deals to turn around and testify, including, with regard to restitution, the co-defendants were obligated to pay like $2,200 or $2,300, where he was obligated to pay $19,000.
Well, it was joint several, though.
Joint several. But when the other co-defendants are having $2,000 and you're getting $19,000, what's the difference? You took it to trial, they didn't.
Well, if they paid off part of the 19, he wasn't going to pay the whole 19.
Well, but they were only obligated to pay
They're 1/7
1/7
of the total amount.
They're 1/7. They didn't break that down for him either. Furthermore, there was an issue of how much insurance paid, whether that was actually even an accurate amount. Clearly, the amount of restitution was in dispute. I know the prosecutor indicates, well, that the sentencing hearing was a restitution hearing. It really wasn't. And the restitution was seriously challenged at the trial court level by the trial counsel, who brought that up and asked for a hearing on restitution, specifically to address whether or not in fact, if I remember, in the record, there's an insurance carrier for the victim, and they even had supplemental insurance for the victim, and it was unclear what exactly the insurance company was going to pay, and thus, what would the victim be out of pocket? Which is another concern with regard to the sentencing in this case.
Isn't Mr. Choate himself a person, I mean, what I'm reading in the brief, it says that Nationwide Insurance claimed $12,500 against him personally. Is what, subrogation?
Well, that'd be subrogation, Your Honor, and they certainly could do that. But that's no different than in an auto accident where somebody injures you, the insurance company pays, and then they go after the driver or go after the claim that you get from the personal injury, in which they essentially get liens against whatever judgment you get. And the irony is that there was no... Just Schaefer, the subrogation would be a civil matter. Here we're talking the criminal matter with regard to that. And that's the troubling part when we do a criminal sentencing. Whether or not Nationwide or a separate insurance company comes back and sues the person who perpetrated a crime and causing the insurance company to pay money is a different question as to whether or not the trial court had an obligation to do an actual restitution claim as part of the criminal case, especially since the ramifications of failure to pay an ordered restitution case in a criminal case could be far worse than in a civil case. Assuming there's parole, or assuming there's an obligation on post-release control to pay the restitution amount, where the person could actually go back to prison and lose his freedom to 1/2 of the original sentence. So that's a far...
Which kind of also calls into question this joint and several liability on a restitution order to begin with.
Correct. No, he does. But all these things indicate that the trial court didn't look for minimum sanctions when it came to addressing Mr. Choate with regard to the thefts from his former employer. It looks like we were looking for the maximums that we could do.
When was he sentenced? I'm sorry, I don't remember.
Your Honor, off the top of my head, I'd have to refer back to my brief.
It was last year, though, right?
It was last year.
Okay, that's
Yeah.
what I know.
But it's the reason that all those like I said, State v. Fallmer talks about overt statements by the trial court. Here, if you look at the actual actions of what the trial court did, that's the reason I raised the fact that the actions sometimes speak louder than words as to whether he was punished for taking it to trial. And it clears that he was, because absolutely everything the worst case scenario happened, everything he did with regard to that, even when you compare it to the co-defendants who pled. And that's where I argue that his constitutional right to trial was infringed by the sentencing because of the fact that he was punished for that, based on, when you compare it to similarly situated people in the exact same case, they got less restitution and less time than the person who took it to trial.
Council, you have about 30 seconds.
We'll have about 30 seconds. Well, in that, I will just wrap up, Your Honor. I'd ask the court to reverse this case, remand it back to the trial court for one, sentencing. First of all, all the grand thefts have to merge under law. Grand theft, and theft are logically allied offenses when they occur at the same place, time, against the same victim. Return it back to the court for resentencing on any prison sentence. Refer it back to the trial court so that we can actually have a hearing on restitution, Your Honor. And I ask the court to go ahead and reverse and remand this back to the trial court to address the errors that were committed in the trial court. Thank you.
Thank you for your presentation this morning. The court will take the matter in advisement and issue a decision, which is mailed to both sides as well as posted on the website.
Thank you very much.